Good afternoon. We have discussed court documents. When we discuss documents, I remember I mentioned charges, summons, abatement notice, and so on. Then we now proceed to discuss procedure of prosecution of sanitary case in the magistrate court. This is the final stage of enforcement process. That is the prosecution of the sanitary offender in court. This occurs in a situation where a person has committed a sanitary offense and has failed to comply with abatement notice issued by a health officer, and this non-compliance may necessitate his arrest by the law enforcement agent, e.g., the health officer or the police. The sanitary offender is consequently charged to court, and court summonses are issued and served on witnesses. The procedure in the magistrate court is summary trial. The environmental health officer is empowered to prosecute sanitary cases in the magistrate court. Before you can proceed on the trial of an offense, you must serve him with a copy of the charge sheet. And I told you that the charge sheet contains the particulars of offense. So we are bringing somebody to court. He must know the offense he has committed. When you have not done this, you are bound to fail if the case goes on and the person eventually is convicted. He can go for an appeal and the appeal can be quashed. So it is important to serve him with a copy of the charge sheet. Then this charge sheet itself must be read in court. Reading of charge. The prosecutors prepare the charge. The prosecutor's prepared charge is read to the defendant by the court clerk. The charge is the particular of details of the offense committed by the defendant as contained in the charge sheet. Then you must allow him to take a plea. The clerk will ask whether he is guilty or not guilty. And at times, his answer may be, well, I'm guilty. He may say, I'm not guilty. Then he may decide to keep quiet, not to answer you at all. If he says he's guilty, then the defendant, then the court immediately proceeds towards sentencing him. Then, if he says he's not guilty, then it means the defendant has indicated that you have to prove your case. So the court proceeds to the mode of trial procedure. Trial itself will involve the prosecutor to make representation, including an outline of the facts of the case. Here, he calls his witnesses to give evidence in support of the case, one after the other. The defendant, that is the defense, also presents his case in defense of the charges or allegations against him. He may call his witnesses for this purpose. Note that the defendant has the right to a counsel to appear for him in court. Then address. If the defendant has the parties are the lawyers, like this, the prosecutor is a lawyer, he has the right to address. If the defendant's counsel is also a lawyer, he can also address the court. And after that, the court will give his judgment. The trial magistrate will decide the case by delivering his judgment. If the accused is found guilty of committing the offense, he has been charged with, he will be punished. Then there is what we call adlocutus. This is the formal sentencing procedure immediately after the delivery of judgment before sentence. When the court has found an accused person guilty and he say, I convict you, then before sentencing him, then at times he may ask, do you have anything to say in mitigation? It is then the lawyer will say, this person is a false offender, he has 3 wives, he has 10 children, he has an aged person. Please, God, please, my Lord, or your worship, don't, you can impose a fine on him rather than sentencing him to a term of imprisonment. Otherwise, the people who actually depend on him will suffer. So here the trial judge asks the defendant if he has any reason why judgment should not be passed against him and sentence imposed. It is an opportunity for the conflict to plead for leniency in mitigation of punishment the court may impose on him. Sentence itself may involve imprisonment or fine, or it may be cautioned and discharged. The court may also give him a consequential order, such as a nuisance order. I've told you that a nuisance order may be an abatement order. That is an abatement order. You must go there. The court may give him a specific date. With this go and abate the nuisance. If as a conclusion of the trial, the nuisance found the nuisance created by him, for which he was arraigned before the court, is still subsisting. He stayed there. The court can give an abatement order. Go and abate it. The other one is a prohibition order. Make sure that this forbidding him from committing the same offense again. And closing order. If the premises is so in a deplorable manner, is so grave, is so dangerous that it's not fit for human habitation, the court can give an order closing the premises. Then, of course, during the trial, if you begin a trial today, if you are unable to conclude it, then you have to, there is what we call adjournment. You have to adjourn the case till another date. So from the next adjournment date, you begin from where you stopped the previous day. That is adjournment, and is part of the procedure of court. Prosecution of sanitary offences. The health officers have the very important role to play when it comes to the prosecution of environmental health offences. To achieve this, the health officer have statutory powers to carry out their functions, which include the following: powers of a police officer or constable, that is, power to arrest and detain any person suspected of having committed a public health offence, power to inspect premises for the purpose of detecting and abating nuisances, and power to prosecute environmental health offenders in the magistrate court, mobile court, or any other designated court. The power to enter premises, right of entry, we have talked about that. Power to seal or close premises. Power of service of notice. Power to sell premises. But before you can sell anybody's property, you must obtain the permission of court. Power to search premises. If that power to search premises too, you have to obtain what we call search warrant, and it is signed by the magistrate. Power to execute a nuisance order. I've told you what a nuisance order is. Power a nuisance order means abatement order, prohibition order, or closing order. Then you have power to seize and condemn contaminated food unfit for human consumption. What is the role of health officer in the procedure of sanitation offences? Of course, we have in a way discussed it previously. General inspection, detection. With the purpose of general inspection, when you conduct your general inspection, then you detect the nuisances, and when you detect the nuisances, you don't just leave it there. You try to make sure that the such nuisances are abated. Then how do you, the process of abatement may involve issuing an abatement notice and giving him a specified date for which he has to comply with it. And during the period, you have to go there to verify whether to verify compliance, whether he has complied or he has not complied. At the expiration of the abatement notice, and you are verified and he has not complied with it, then you have to start the process of charging him to court. And the process will begin by preparing a charge sheet. It is the responsibility of the environmental health officer to prepare a charge sheet. When you prepare that sheet, you make a complaint to court. How do you complain to court? You now file the charge sheet in the magistrate court. The responsibility of the court is now to issue a court summons. We have discussed what a court summons is. A court summons is a document issued by a court, by the magistrate, asking the person who has been alleged to have committed an offense to appear in court at a stated date for his defense. And I told you also that the summons can also be issued on the witnesses to come and testify in court. So as soon as the court will issue the court summons, when the court summons is issued, it is served on the offender to appear in court. And when he appears in court, the hearing, the trial will take place. And he may insist that the prosecutor is in court. The offender will need to defend himself. We given adequate time to defend himself, if possible to call witnesses. And environmental health officers may act as a prosecutor to prosecute the case. He has the power of a police constable. The environmental health officer may also act as a witness. Where the accused is found guilty, punishment is meted out in terms of fines and terms of imprisonment. One judgment is obtained against the defaulter. The environmental health officer will see to it that the judgment obtained against the offender is enforced. If the nuisances are yet to be abated as at the judgment, the environmental health officer may apply for a nuisance order. I told you, maybe an abatement order, provision order, or closing order. I've been emphasizing on this nuisance order because most students don't know it, and you should learn it. An abatement, a nuisance order may be an abatement order, a prohibition order, or a closing order. Appeal. If the defendant is not happy with the judgment and he feels he has a ground for which he can appeal against the judgment, he has the right to appeal. Any aggrieved party may appeal against the court judgment to a higher court, and in most cases within 30 days. What is the role of environmental health officer in the enforcement of court orders? You have to monitor the compliance. After the court must have given judgment, maybe the court must have given, if the court has given a nuisance order, it is the responsibility of the environmental health officer to go and verify whether that person has complied. If he has not complied, for every day he has failed to comply, there is a punishment in terms of payment of is liable to a fine. Like it ranges from 100 naira and up to 200 naira a day of default. For any day he has defaulted, he may be asked, he may be fined from 100 naira up to 200 naira. And EHO may enter the premises. He has the right of entry between the children in order to ensure that such order is executed. And he has the power to sell premises. I've told you that before an environmental health officer can sell any premises, he has to obtain a court order. And if within 6 months, then whatever the environmental health officer can abate the nuisance on his own if he cannot find the convict. In that case, anytime it is still the whatever money, whatever expenses you have incurred, it is the convict that will be responsible. If by 6 months of the execution and the environmental health officer has incurred the debt, incurred whatever expenses, then he can decide to sell the premises, any movable property of such owner or occupier, and the court order. So you now know what right of entry is. Then order. Any order means, an order means a command, direction, or instruction. It may also mean a written direction or command delivered by a court or a judge. Example is a court order. We also have judicial order, and it is mandatory. But note that although command which we are talking about is from a constituted authority, of course we have another command when, God forbid, that we meet an armed robber. You know what he does, he uses also a command, your life or your money, and that's a command, but it is not the type of command that is authorized. We have talked at length on what a nuisance order is. Writ of certiorari. This is an order which commands a judge and of lower courts to transfer suit to higher courts to ensure a fair trial, especially when the lower courts have no jurisdiction to hear such cases or have exceeded their jurisdictions, or if the record of proceedings reveals an error of law. Certiorari may be issued to remove a suit from an inferior court, to secure an impartial trial, to review an excess jurisdiction, and to challenge or traverse act, quash a judicial verdict that breaches natural justice, and correct errors of law, and to correct errors of law caught on the face of the record. The primary purpose is to enable a superior court to review the record, to adjudicate the legality of the decision based on it. What is on order of mandamus? A judicial order which compares or directs a lower court or any institution to carry out a duty of a higher court when justice seems to be delayed. It commands a body or person to perform his or his roles under the law. It is simply a device for securing judicial enforcement of public duties, and summons a judicial order directing a person alleged to have committed a wrong to appear before a court, tribunal, or panel. A relevant witness may be compelled to attend court by witness summons. This takes us to injunction. Injunction is a judicial order to restrain a person or institution from carrying out a certain action. Injunction may also be perceived as a court order commanding or preventing an action. There are three major reliefs which a court of law can grant. They are interim injunction, which is grantable ex parte, interlocutory injunction, and perpetual injunction. We have other types of injunction: ex parte injunction, interlocutory injunction, perpetual injunction, prohibiting injunction, reparatory injunction, manreval injunction, and compiler injunction. Ex parte injunction is a sort of interim injunction. The other party is not there, and it is because it is actually when you approach a court, because the matter in hand is very urgent, and it must be urgent. If it is not urgent, if you ought to have brought it some days before, the court may not grant what is called the ex parte injunction. Where interlocutory injunction, this is a temporary injunction granted before or during trial to prevent an irreparable injury. from occurring before the court has the chance to decide the case. The injunction will be issued only after the defendant receives notice and has opportunity to be heard. Unlike the ex parte injunction, where only the moving party, the party bringing the action to court, is there and argues it. Unlike the interlocutory injunction, the other party must have been notified and must come and will defend it before such an order can be given. A perpetual injunction is like after the judgment. After the judgment, the court gives a permanent order. So this is an injunction granted after a final hearing on the merit. It's not automatic with any claim. It must be specifically claimed. And we have prohibitory injunction, an injunction that forbids or restrains an act. Preparatory injunction. This is an injunction which focuses on returning the plaintiff to the rightful position after the wrong has already occurred. Marital injunction. This is a form of injunction whereby the defendant could be restrained from disposing of his or alienating his property so as not to frustrate or render nugatory the judgment that the plaintiff may obtain in the case before the court. It may be granted in an interlocutory application or ex parte. And we have a Tom-Piler injunction. This is a court order that provides the right to enter and search premises and seize evidence, which may be documents and other relevant items, without prior warning. This is intended to prevent the destruction of such relevant evidence. This is why we are going to stop now, and when next we will start on government.